Good morning, friends and colleagues, and welcome to this ThinkLegal webinar in association with Fair Practice. It's absolutely wonderful to see all of you here with us this morning. Everyone watching on StreamYard, Facebook, LinkedIn, and YouTube. It is absolutely great to have you with us. Nadia is going to be sharing the link to view on our WhatsApp channel shortly. So as the room starts filling up in anticipation for our presenter this morning, I'd like to take you through some housekeeping in terms of what we have in store for you today. So, by way of introduction, folks, my name is Mervyn Vermeulen. I will be your host for this morning, and it is my job just to welcome all of you and to ensure that everyone feels welcome. Joining me this morning as our admin is Nadia Vermeulen, who is going to be ensuring that from a technical point of view, we are good to go. And then last but not least, and I'll do a formal introduction for her, but later, Advocate Virosh Shrikasan, our presenter for this morning. So please feel free to type questions, comments, queries in the comment box, as I see a lot of you have done already. If you are watching on YouTube, please simply comment on the video and we will answer any questions you have there. If you are watching on LinkedIn, please do likewise. And then if you are watching on StreamYard, we have a formal chat bar on the right-hand side. Our presentation this morning, Mediation Matters, presented by Advocate Virosh Shrikasan, and she is going to be taking us through Mediation Matters, an introduction to mediation advocacy. So, for those of you who are not yet involved with some of the ThinkLegal initiatives, please go to thinklegal.co.za. You are welcome to register for events, join one of our WhatsApp groups, or join all of our WhatsApp groups if you are brave. You can purchase some resources and you can view past webinars if you are unable to watch webinars live. So, folks, what is ThinkLegal? It's an initiative by Vermeulen attorneys which aims to promote the open sharing of sound legal knowledge. We acknowledge that delivery of legal services is for the most part a commercial venture, but we also uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. For this reason, we do various webinars, events, WhatsApp groups, etc., all with the aim of facilitating communication amongst legal practitioners and associated professions. So, shameless punt before we get into our webinar this morning, into our content. ThinkLegal, supported by Vermeulen attorneys, obviously, and Lawbox practice management software by lawyers for lawyers. Try Lawbox free for 14 days. Lawbox.co.za. For those of you who are around during the holidays and are looking to keep yourselves busy, please join me next week, Friday, for the Family Law Roundup free webinar, where I will be looking at 20 of the most prominent cases and developments in family law during the month of March 2024. That is next week, Friday at 9 o'clock. And then finally, for those of you who are interested in attending our Children's Act Deep Dive, that is taking place on 23 and 24 April, 2 evening sessions, 5:30 to 8 o'clock. We'll be looking at general principles of the Children's Act, children's litigation, and frequently encountered issues. $750 per person standard tickets, R500 per person for candidate attorneys, and we will, in those instances, ask our CAs just to provide confirmation of registration of their articles. So, for those who are aching to get some delicious CPD points for our Family Law Roundup next week, you can earn 2 NABFAM CPDs issued by SAM and by Social Justice. If you purchase our course pack, that will be communicated closer to the time. And then for the Children's Act Deep Dive, 5 NAPS FAM CPD points underwritten by Sam for your attendance. So, shameless punts and admin out of the way, it is my distinct privilege to introduce to you our speaker for today. So, Viraj Shrikasan is an admitted advocate and the founder of Fair Practice, dispute resolution services organization based in Johannesburg. She has been involved in ADR since 2010. She's a Harvard-trained mediator and negotiator and has presided as a judge in civil and commercial mediation negotiation competitions globally. She's a cum laude graduate of the Arbitration Foundation of South Africa in alternative dispute resolution and is the lead trainer for Fair Practice, AFSA, and SA Legal Academy in mediation skills training. Her mediation skills training program is nationally accredited through the South African Board of People's Practices and internationally accredited by International Mediation Institute. To date, Viraj has trained over 500 professionals in mediation and negotiation skills. And as an aside, I can assure you that you are in for a treat learning from Viraj this morning. So, without any further ado, it is my absolute privilege and pleasure to hand over to Viraj as she takes us through Mediation Matters, an introduction to mediation advocacy. Please post your questions and comments in the chat bar. Nadia and I will be moderating, and those questions which really pique our interest, we will pop up on the screen for Viraj to comment on. So, Viraj, if you could please unmute yourself, then it is over to you.
Thank you, Mervyn. And wow, what an introduction. I know it's a mouthful, but it really, when I speak to everyone, everybody gets to a point of becoming quite fully fledged mediators once you embrace the practice of it. And I have really committed myself in the practice of ADR. And that's why this topic came about. And we discussed amongst ourselves why we need to bring this topic to people to get them to understand why mediation matters in dispute resolution. So today we will explore the essence of mediation, its impact on individuals and communities, and why it should truly matter to legal representatives to learn about the mediation process. So welcome and thank you and hello to everybody who has joined us, who will be watching this at a later stage, who are watching it right now. Thank you for your time. Thank you to Mervyn and to Nadia for making this webinar happen. Thank you for all who have registered and who want to learn this information to pass it on, hopefully to legal representatives who are open to learning more about the mediation process. So this webinar is developed from my own experiences with mediating amongst clients and their lawyers, and I found there to be a communication challenge between lawyers and their clients in terms of explaining the mediation process between the parties, and there's uncertainty around how to navigate through the process. And I found that, as Mervyn mentioned, there are WhatsApp groups who support legal practitioners, who support mediators. And often the discussion is, how do we get legal representatives to understand that mediation is not a threat to their or an impact negatively to their profession. It is not a negative impact to their income earnings. And this webinar is going to revolve around getting lawyers and clients to understand why we have mediation as a dispute resolution process that is now a global practice. It used to be a practice amongst tribes. It used to be a practice amongst communities, not just in Africa, in other parts of the world as well. However, now that we have this Western style of mediation, people are still afraid to walk this path. They want to understand, why utilize mediation when I know if I go to court, I will get what I want. Not necessarily true. And mediation training teaches you that. It teaches you how to look at alternatives, how to look at options, to look at ways of creating solutions amongst each other. So this webinar developed from a larger webinar called Mediation Advocacy, and I've taken a piece of it. So I might not be able to get through the entire Mediation Advocacy webinar that is hours long. I'm actually going to go through a few aspects that I found to be pertinent for legal representatives to understand why they have a greater impact in the mediation process than they think, and they actually are not excluded from it. So I'm educating lawyers and clients through the mediation process in my own practice, and I'm hoping that you share this information with lawyers and practitioners as well, in understanding that mediation has its benefits. It will give you, your clients, if you're in a workplace environment, employees, your work colleagues, a better understanding of most of the mediation process. So this is a foundational understanding. Once you leave here, you're not going to be a qualified mediator. That takes hours and years and months of training to be regarded as a skilled and competent mediator. So this is just a foundational, basic understanding of mediation. So why mediate? Well, mediation is a process that is ancillary. Firstly, it's ancillary. Please understand that it is not the be all and end all. Yes, it can reach resolution. The parties can come to decisions. However, it is ancillary to other dispute resolution processes because it is used when suitable and appropriate. So it is not saying to practitioners, it's not saying to clients, once you go into mediation, you have to stick in there and reach an outcome. Not always. Mediation can be used in various scenarios. In scenarios where parties are amicable, then they can reach resolution if it fits the time and the circumstances. In instances where it is better to use mediation to identify the issues, then use mediation to identify the issues. Where some issues can be mediated and resolution reached, so be it. I don't ever speak of mediation as a failure. In fact, I had one recently, and the parties used mediation to actually start communicating with each other. They used the process to actually engage. They were just sending emails. They used this process to actually verbalize communication with each other. And then from there, they decided to proceed on their relationship, on whether it should continue to exist or not. Now, that is an ongoing mediation, and it will continue for a very long time, not just 30 days, not just a week, not just between us now in this 1 week that we spent with each other. It will continue over months. And that's the beauty about mediation. When clients come to you as their representative, you cannot explain to them unless you know fully how long mediation takes, because they will ask you, is mediation going to take a day? Is it going to be a week? Is it going to be a month? You cannot actually define a time limit. There's guidance that it could be 30 days. However, that's a guide, because mediation is a voluntary and confidential process where a neutral third party assists the disputing parties, the mediator, in reaching a mutually satisfactory resolution through facilitated negotiation. So we can't say how long a negotiation might take. However, a competent mediator will be able to identify if there's an abusive process. Now, client representation in mediation is optional, okay? Unlike litigation, where you have the winners and the losers and the legal representatives are fully engaged, mediation seeks to find common ground, and the mediator speaks directly to the client. So it encourages open communication, understanding, and collaboration. So client representation there comes from you being the client's lawyer. You're not the speaker at the mediation. More likely, you're the observer. Where you're giving legal advice, you're doing it outside the mediation, or you're doing it separately with your client in a facility or in a space that the mediator creates for you and your client to engage in. So when your client approaches you and they start talking about what their dispute is about, and they want to know, well, what do I do now? They're seeking advice from you. You know that a chain of events have occurred before they walked in through your door. Clients their default reaction when there's a dispute, when there's tension, is to go to a lawyer. They instinctively want you to tell them what to do as the lawyer. Or firstly, they do go to family members or they go to friends where they vent. And most times, those people say to them, go get yourself a lawyer. Unless, of course, that lawyer is a family member or a friend, then you've got to understand whether there's a conflict of interest there. But if you are a lawyer who is consulting with your client, puts you in a privileged position to determine what should come next for your client. So you are now the conductor of preparing your client to choose the steps to reaching resolution. And mediation is a possible step towards resolution. So you engage in preparing your client to first think about mediation by explaining what the process entails. Initially, parties will always be apprehensive about directly engaging in negotiations, and they want their lawyers to handle all the communications. But here's the missing link here. How does a lawyer explain to their clients what happens in mediation if they themselves don't know? They have not attended mediation training. They have never dealt or been party of a process in mediation. They do not know the basics principles of mediation. They don't understand the self-determination, the autonomy of the client to determine the outcome. So this webinar I'm hoping, gives legal representatives an insight into how to explain to their clients the purpose of mediation, the function of the mediator, and the possible outcomes from mediation. So here, let me get back to you sitting with your client in consultation. Once you have heard the issues in dispute and you understand the needs of your client, your role would now be to educate your client about mediation. And we're going to help you today to understand some of it and why it should be attempted if it is appropriate. Now, in preparing your client for mediation, you will conduct a risk analysis. So you will sit with your client and you will identify the issues. You will scope out what can be agreed upon amicably amongst each other if they have that sort of relationship. And you always say to your client, while we are defining the issues here in consultation, there's always room to add more issues as they arise. Now, that is a mediator skill as well, because mediators do that when they're creating the agenda. They always tell clients, this is not the be all and end all. It's not cast in stone. We still have the opportunity to take this discussion further or see how it goes in terms of whether you want to keep it as an agenda item or you want to remove it. And that style of communication is also open to legal representatives to analyze what is most important, what is urgent, what it is that they actually need from you as a legal representative, and the outcome they want from this dispute. What is imperative to them? So you provide the advice. You, the legal representative, provides the advice. A mediator does not provide advice. And there's another thing, there's another bit of information you can tell to your clients. The mediator should not be advising you. The mediator shares information. Usually the information is shared exactly the same with the clients in a joint session or an individual session. And I'll explain more about that later. So you tell your client about mediation in a way that it gets them to understand that this is an actual dispute resolution process. And it's not about you washing your hands of them. You're not sending them off to a mediator and never see them again. You do still get involved because there's memorandums of understanding that come out of these mediations. There's agreements. There's possible contracts. So you are still involved in drafting documents. And the mediator, if there's discussions with you and the mediator during the process, you will see that the mediator can pass this function and role on to the legal representatives. The parties may reach agreement on that. So you are still back in the game when it comes to drafting, because both parties would like to confirm the contents and they need someone like you to just go over it with them and say, yes, I was in the mediation with you, or I understand why, if you were not in the mediation, I understand why, you help me understand why you came to this decision. It's not for the legal representatives to then go take whatever the client has decided on and tear it to shreds and say, I can do a better job about this. We do see this in industry. We do look at this with side eye and say, listen, guys, legal representatives, the clients really worked hard on creating these decisions for themselves. So help them to understand how you can make this either court order, or you can put a stamp on it to say this is part of a contract, or we need to amend or vary contracts in terms of these new decisions, or something was not working in the past, and with the decisions you've come out in mediation, we can now add on to that. So we're looking at lawyers and legal representatives to behave in a collaborative way, but to approach it in a very mature and responsible manner. So legal representatives need to be people who understand negotiation strategy so that they're able to guide their clients on how to share information for a beneficial outcome that is mutual for everybody. Now, that means in that negotiation strategy, and what we often see in this, and I'm relaying to you what has been coming out in all the discussions that I've been seeing on social media and on WhatsApp groups, is the destructive nature within that negotiation strategy that lawyers send their clients into mediation with. In mediation, ultimately, what the mediator is moving towards is an amicable atmosphere where the parties are willing to listen to each other, including the representatives, and understand each other's perspectives. If you are coming with a negotiation strategy to derail the process, and you've told your client to use this mediation process to gather as much information that you can use in court to the detriment of the other party, you're not entering that mediation and that facilitated negotiation in good faith. And again, a skilled mediator will pick that up as a sign of abusive process. So you want to give your clients a good chance of being successful in mediation by reaching a mutually beneficial outcome. A competent mediator will be able to know when a lawyer has influenced a client with hard tactics, with tactics that cause the negotiation to fall apart, where clients are then blocked. They are facing challenges from seeing the perspective of the other side, where clients come ill prepared in understanding the offers and the options put on the table. A skilled mediator would be able to see that. So what we'd like for legal representatives to do is to understand the interest-based negotiation strategy that forms part of the negotiation inside this dispute resolution process. And that comes from the lawyers themselves having to open themselves to understanding that this mediation process is about coming properly prepared to listen and to actively participate in a constructive manner in mediation. Now, once the process has begun, you will have to engage with your client further if they decide to come to you for advice, because a mediator would say to them, I'm not here to advise you. However, should you have a legal representative, please seek advice from them. So post the beginning of that mediation, you can follow up with your client and understand how far they've gone, not derailing the process by saying, well, you've had your first session. Let's tick that off our charts of things to do. Now, let's go back to our process of going into a trial or continuing the litigation. That's not really what happens once the mediation begins, and that's not really what should happen coming from the legal representative. You should be able to advise your client on what it is that they need more legal information on, and to check on the progress of the mediation. At the same time, your legal proceedings are stayed. When the mediation begins, it's stayed. You stop engaging in any other tactics that could derail the negotiation. So do you attend the mediation then as a legal representative? Not necessarily. It may be conducive if the mediator feels that it's going to be a balanced process, having you in the room and the other party has their legal representative in the room. That may happen. The client decides, though, because again, it's cost bearing on the client to have you in the room, whereas the mediator is engaging with the client, not the legal representative. So there you have to weigh whether it is necessary with the client, whether it's necessary for the legal representative to be there. And the dialogue that is engaged in does not mean you are going to be speaking on behalf of the client in the negotiation, unless you are an agent of the client and you have been given authority in the client's absence to enter into the negotiations and to negotiate on behalf of their client. But where I'm speaking of clients who go with their legal representatives into a mediation, the mediator is going to engage with the client. The mediator is going to ask the client to engage with the other client in a joint discussion. So you have to be able to weigh up what happens in that mediation process and whether your presence is necessary. So the post-mediation support you have there is the lawyer playing a role in ensuring that the agreements are reached, are legally sound, and they reflect the intentions of the client, and any necessary documentation that the mediator speaks to the client to about, or the parties about, the lawyer can assist in obtaining those documentations for the client. Now, mediation is not therapy. We know that a lot of people come to mediation. There's that conundrum of the word mediation, meditation. It's not therapy. Why is it not therapy? Because we have court rules that recognize mediation as a dispute, formally recognize it as a dispute resolution process, adapting to the needs of the clients. In terms of court rules recognize that not every dispute should come to court. It allows the clients to please first consider mediation. So here I'm not going to go in depth into the court rules. Do have a look at Rule 41A of the High Court Rules and Chapter 2 of the Magistrate Court Rules in South Africa. And these rules recognize mediation as a formal dispute resolution process. It speaks to the principles of mediation, the mediator, the timeframes, the process of informing and inviting parties into mediation. So as a legal practitioner, should be your duty to get well versed on these rules, because your client is going to ask you again, what does it look like if I go into mediation? You need to understand, what do these rules entail? Every mediator understands what those rules entail. If you want the mediator to explain it to your clients, they are more than welcome to do so. However, building a relationship with your client and moving them into a mediation process, by explaining to them these rules, they now trust that you are seeing their interests at heart. You're taking their interests to heart. You're seeing the importance of addressing their interests. So while mediation is unregulated, and it does allow any person over the age of 18 to learn mediation skills and practice with a minimum 40 hours of training, and no client is forced to choose a mediator based on proximity, you as a legal practitioner can assist your client to find a mediator that is suitable to their needs. So in that instance, you would look at the issues, because you've prepared your client on the issues going back. Now you look at the issues. Who would be the most competent mediator? And we can choose from 3. Who would be the most competent mediator to suit the needs of the clients, of the parties? You will explain to the clients the efficiency of mediation. Having that direct dialogue between the parties, mediation does not go into the personality and characteristics of each party. That's therapy. The mediator is equipped to identify the conflict style of a party and work with them in that state of their conflict style. Therapy, on the other hand, speaks to the history of a person's emotional state and what are their underlying causes that control their actions. So therapy unpacks behavioral conduct of the parties, and it delves into their past experiences and what's leading to them behaving in that manner. Whereas mediation speaks to the now. It speaks to the way forward with very little emphasis on the past, except to acknowledge what can be done differently. So it will address what happened in the past and then move on to addressing what can now be done differently to reach an amicable, mutually beneficial outcome. So the mediator, through their communication skills, is able to identify common areas of the needs of the clients that will bring about a realistic resolution. We're not talking about someone who's going to become a therapist to the clients and then switch into mediation mode. There should be a fine line in identifying who the therapist is and who the mediator is. So there is a collaboration of services there that and professions that offer therapy, whereas they will outsource the mediation to a different professional. A mediator will look into what is preventing the parties from negotiating effectively, and it will bring parties to understand each other's perspectives. A therapist will look into the background of what is causing emotional stress on a party. Now, coupling therapy with mediation brings about emotional regulation, and this will assist in moving the dispute resolution process forward. And herein lies the cost effectiveness of it. You do not want parties, if you as a legal representative can see they're not in an emotional state to negotiate effectively, you do not want parties to waste costs sitting in a mediation to negotiate when they are not emotionally ready for that. So, as a legal representative, you should identify which professional the client needs to be seeing as they prepare to go into negotiation in mediation. Now, to do that, in understanding the process of mediation, we need to look at the principles of mediation. The principles of mediation are the guiding framework that shapes the entire mediation process. These principles are essential for creating an environment conducive to constructive communication, understanding, and collaborative problem solving. Now, voluntary participation. The rules say that it's mandatory to consider mediation. It's not mandatory to participate in mediation, not in South Africa as yet. Voluntary participation means that the people involved, the parties involved, engage in the mediation process without coercion, which means it is voluntary to stay in the mediation process until they reach agreement. It doesn't mean that if you are mandated by court to attend mediation, you have to stay till the end. We are not forcing people to stay in mediation if it is not conducive to them reaching agreement. And a mediator, again, would be identify if the parties are not ripe for mediation just yet. Now, again, as a legal representative, you cannot influence parties to just get up and leave, because you have to allow them to close the mediation process and say, this is not something we want to deal with right now. We are not ready to deal with right now. So while you close the mediation process with an understanding that you can come back, know that mediation, again, doesn't fail because the mediation doors remain open constantly. Parties can come back even after they've reached agreement, even after there's a court order. If something does not work, they can still come back and talk about it in mediation. There are some clauses you can draft in your agreements and the MOUs, or you can look out for it, where clients can put in review clauses. So once everything is done and dusted and they're quite happy and they want to come back, they can each voluntarily participate in mediation to come back and make any changes that they want to. So don't feel that participation in mediation ends if you decide this is it. I don't want to be a part of it. I want out of it. I deal with clients a lot again in my practice where we do have mediations that go for a week or go for a month. Clients say, listen, please stop. I'm not ready. I need to go get more information. Can we put this on hold for 2 months? And you can do that. So do understand that participation is voluntary. It varies between the parties. If parties, again, we'll talk about it not being conducive, mediation not being conducive, but do understand that participation is voluntary. Now, the confidentiality principle. Mediation is a closed process. Unless there's a need for information to be shared to protect the safety of the clients or if criminal activity is revealed, the success of mediation is based on building trust within the process and relies on confidentiality. So the mediator, when meeting the parties, one-on-one will only share information amongst the parties if they are given permission to do so. In the joint sessions as well, whatever is shared remains confidential, and the parties, unless they agree jointly, can make it public knowledge once they've both agreed to it. Without prejudice, admissions, concessions, offers are done so without prejudice. Again, nothing is cast in stone until the parties decide or they agree on a particular issue. The mediator, and I've spoken about this mediator, the mediator has to be impartial and remain impartial throughout the process without any bias, favoritism, or conflict of interest. So you as the legal representative, here you come in again. You assist your party and along with the other legal representative in identifying the appropriate mediator. What we do in practice is people, and I've seen this recently on WhatsApp groups where people request mediators and they put names in a hat with the credentials of that mediator, and they narrow it down for the clients as to who is an appropriate mediator, and everybody agrees jointly on who should be the first choice of mediator. So you're looking at a mediator based on their expert knowledge, their experience, word of mouth, their competency. And as a legal representative, you have your ear to the ground. So you know, and you can advise your clients on particular mediators. Again, remind your client that the mediator does not advise, they do give information. The mediator, as a legal representative, you need to be aware that the mediator has no vested interest in the outcome. So be wary of mediators and how they conduct themselves. The mediator must ensure a fair process. So when you are doing follow-ups with your client, ask them, how do they feel about the process? Don't feel insulted if they say they like it, it is fair, they're enjoying it, they're actually moving a lot faster than they would had they gone litigation. It's not an insult to you. Don't take it personally. This is exactly what you want for your client. You want to see clients that are happy, that are getting benefit out of this dispute resolution process. Now, when you talk about self-determination, this is where lawyers do not fully understand, and which then falls onto their clients, that self-determination emphasizes that the parties themselves have the right to make decisions about the dispute resolution, about the resolution of this dispute. And that means that the mediator will not impose a solution or an answer. Instead, the mediator will, using their skills, using the negotiation part of the mediation, empower the participants to shape an agreement that aligns with their needs, values, and priorities. So you must, legal representatives, you must tell your clients that in this process of mediation, they determine what the outcome is. They have full control of the outcome. The mediator controls the process. The clients control the outcome. So during negotiation, the clients will depend on you lawyers to assist them in understanding how the analysis works on what would be a good offer, what would be an offer they can present, are there alternatives outside of the mediation, reality test what would happen if they walk away from the mediation and go into litigation. You can advise them onto what court processes look like, delays, not understanding the needs of each other, exchange of information, how long the time limits will be. So you are working with your client to understand that, yes, you have autonomy in deciding within that mediation the outcome, because that is what the process of mediation is. It gives the clients the control and empowers them to put their needs on the table. Now, mediation is not an evidence-based process. So the mediator will not likely provide an outcome based on documentation that they receive from lawyers. So chances are the mediator is going to tell you, don't send your case files to me. Just give me an opening statement of what is happening with your client's issues, and just give me a brief outline of these issues. The beauty about mediation is that it addresses both the monetary and the non-monetary values for each party. And I repeat, It is not something that the mediator will off the cuff say, because I have a global view of what is happening in this mediation, I can tell you both what is the best outcome. Now, the communication in self-determination, in that part of self-determination, happens in individual and joint sessions. Most mediators use individual sessions to get parties to reality test their offers and their options and their alternatives. So, as a legal representative, speak to your client about this part of the process, that they should not be alarmed if a mediator separates them into individual sessions. There shouldn't be any suspicion that a mediator is going to go into a separate session and then badmouth the other client. That's not what a mediator does. The separate sessions are really there for a mediator to obtain clarity on what is going on in the mind of the client. And for instance, why are they not accepting an offer that has been placed on the table? What is holding them back from moving forward? So if your client is reluctant, especially if there's a pre-mediation meeting with the mediator and the mediator explains, well, we're going to have individual sessions and we're going to have joint sessions, and the client goes, whoa, what do you mean individual sessions? I want to be in the room constantly to hear what the other person says. The mediator and legal representative, you explain to your client that these sessions, these individual sessions, about obtaining clarity, and it is confidential unless the mediator has permission to share that knowledge. So alleviate any hesitancy the client may have in engaging in those individual sessions. Now I want to move on to the mediation scenarios where mediation might not be appropriate. I see your question, Jennifer. I'm going to go through the content because I am running a bit late with a lot of the content. So I'm going to come back to you, Jennifer, after I've done the presentation. So mediation scenarios may not be appropriate. And again, this is a brief overview of instances where, as legal representatives, you would understand why a mediator might say, this situation that you're bringing to me, these circumstances you're bringing to me are not conducive for mediation. So the first one is an imbalance of power. Now, again, we do have imbalance of power in litigation as well. One party will have more resources to engage a full legal team, while the other party may not. Those things happen in litigation as well. In mediation, though, what we're talking about in terms of an imbalance of power is where a party feels coerced or unable to express their concerns openly. Now, a mediator, again, this is where the individual sessions come in handy, will use these sessions to understand fully why a person feels that they are unable to be a part of the mediation. Because the mediation relies on a level playing field, and in order for the negotiation to be successful. And where this is lacking, mediation at that particular moment may not be the best option. Again, working with other professionals, the mediator will then try to move the party into the next available dispute resolution process or therapy, so that the person does not feel that they're being victimized while they are trying to negotiate. People should feel, and the party should feel, free to express their concerns and needs to the mediator. And what we also want to look out for are desensitized mediators who cannot see in front of them that they are imbalance of powers, and they force parties to reach an agreement when that person is really not ready to do that. Safety concerns, where you can see, and that also ties in with an imbalance of power, where there are concerns about physical or emotional safety, especially where there's cases of abuse. Mediation may not feel safe for the parties, and I'm not going to go into the domestic violence practice, the directive that's come out, because again, that's ongoing discussions. So where party feels, what I'm talking about here is where party feels vulnerable and they feel intimidated or fearful. If a mediator continues, and if your client is coming to your legal representative and saying, this is how I feel, and the mediator is pursuing mediation despite how I feel, you then know that this compromises the integrity of the mediation process and the outcome and the decisions made subsequent to that. So You are now needed as a legal representative to understand, is my client getting the best out of the mediation process? I need to address this with the mediator. Maybe the client does not address this with the mediator. You can advise your client to say to the mediator, this is how I feel. I'm feeling pressured. I'm feeling afraid to speak up. So you here, you're a translator, you're a conduit, you're a messenger of what is your party going through in that mediation. There's a need for precedent. So where there's a need for a legal precedent, mediation will not be the appropriate dispute resolution process, because, for instance, landmark legal disputes require a court decision to create a binding precedent for future cases. Where the parties are unable to participate or negotiate due to mental health issues or cognitive impairments or language barriers, it may hinder the effectiveness of the mediation. So just be aware of that as well. And in such cases, accommodations or alternate dispute resolution methods other than mediation may be necessary. Where there are urgent legal remedies, and your party needs to seek assistance through a court system rather than relying on potentially what would be the mediation process and the time to discuss in a mediation process, then mediation will not be appropriate in those instances. So, as lawyers, you need to carefully evaluate the circumstances of your each case and advise your clients accordingly, while keeping in touch with your mediator as well. Now, what happens if there's a lawyer in the room? Okay, let's talk about the lawyer in the room. Why should lawyers consider mediation? We've spoken about instances where you should be wary of it, but let's talk about now. We're with our clients. We're talking about mediation. Why should we consider it? Well, time and cost efficiency we've spoken about. Where there's urgency, of course, measure your client's needs and urgency. Not everything is urgent. It could be. I was recently in a mediation which has now come out, that's gone to court in case law, where the judge actually said this could have been mediated, but the one party refused to continue the mediation. Measure the urgency. Mediation is cost effective more than litigation because it involves few hours of preparation, less time in court, and lowers overall expenses. And this can be appealing to clients who come to you and say, I'm facing financial burden, I cannot proceed with legal proceedings, but I do want a resolution. So you assist with narrowing the issues, and you make room by using mediation for direct negotiation. So time and costs are reduced. Where there is a relationship, and you need to understand that there are family relationships or workplace relationships, or even business disputes amongst family members, mediation provides a platform for parties to communicate and collaborate in a more amicable and constructive manner, which preserves that relationship. So it teaches them, it gives them skills on a life beyond this dispute. So, as a legal representative, you need to be patient with the emotional and psychological element behind the dispute. A well trained mediator knows how to handle the emotions that the parties are displaying, and they will allow for the emotions to be present in the process. You need to explain to your client that despite the mediation process not being therapy, the mediator is trained to understand that there are emotions in the room, and these emotions are going to affect the relationship that the parties have. Now, a mediator will identify if this relationship needs to be preserved and will work with the parties accordingly. Where you actively, as a lawyer, promote alternate dispute resolution methods, including mediation, you will be viewed favorably by your clients and peers, because embracing mediation showcases a commitment to efficient and client-centered resolution practices. So with you as a lawyer, legal representative, walking with your client through mediation and the negotiation with it, helping them to articulate their needs and preferences, what you're going to be doing is ensuring client satisfaction. And that in itself expands not just your practice areas by understanding mediation, it it'll expand your client base. So understanding that the confidentiality, the flexibility of mediation allows for the clients to become creative in developing these outcomes and these resolutions. It adds to your professional reputation. It means I'm focused on my client. I want the best for my client. So all of it sounds nice. It all sounds like, yeah, I'm for my client. I it's really great. I'm going to have satisfied clients, and I'm going to have a very good reputation that I spend all this time and effort in ensuring that my client walks away happy. But do I lose my client from this? I don't want to lose my client. If I play nice with the other professions, is it going to cause me a loss in fees? The traditional adversarial approach that lawyers are trained in, that students are trained in, and I'm hoping someone from the university could come to us and say to us, please teach our students about alternate dispute resolution methods as a way to get client satisfaction. The traditional adversarial approach, where cases go to court and it leads to this prolonged and contentious process, is viewed by is makes lawyers view mediation as a way of potentially reducing billable hours. Now, we know that lawyers charge by the hour, and mediation is a shorter process. Lawyers who rely heavily on billing hours perceive mediation as taking away time and revenue. And there's this perceived competition for clients. And if clients opt for mediation instead of litigation, lawyers may feel that they are losing their clients and revenue to mediators. But here comes a lack of understanding about the complementary nature of lawyering and mediation. And I spoke to you earlier about mediation as an ancillary process. This lack of understanding is because lawyers don't fully grasp how mediation can enhance their practice. And I've been talking to you about that from earlier this morning, how mediation provides additional avenues for dispute resolution and client satisfaction. Yes, there are economic pressures within the legal industry with increased competition, market saturation, and lawyers can view mediation as contributing to this challenging economic landscape. So they might see it as a factor that further intensifies competition for clients and cases. And that leads to a fear of losing control, especially when lawyers are accustomed to the traditional adversarial system and they feel they are losing control of the resolution process because, as you've heard, the mediator talks to the client. The lawyer is an observer. There are instances where the lawyer is not in the process and they are advising from the sidelines. The mediator takes on the facilitative role, and lawyers worry about that dynamic and the impact it has on their influence and control. So this is why I ask you, lawyers, to please be wary of your nature when viewing mediation as a collaborative process. You need to understand the benefits of the mediation and view it as a valuable complement to traditional legal services. And it can offer efficient and collaborative solutions. So again, I'm saying to you, as I said earlier, you play a crucial role in advising clients through the process. Now, the lawyers who learn about mediation, will they become better lawyers? Well, today you're learning about mediation advocacy in terms of what you understand. Mediation advocacy is not detrimental to your client. You will explain that to your client. Mediation skills training teaches communication skills, and it focuses on getting the full in-depth story of what drives the dispute or the conflict between the parties. And you know this, lawyers. You know when you sit with your clients, are they really telling you the full story? Sometimes that apprehension that I was talking about that comes from lawyers of losing control, sometimes it comes because you may have this understanding that the mediator is going to get the full story, and then they're going to drive the outcome in terms of influencing the client. So using and gaining mediation skills, especially the communication skills, gives you the added advantage of getting your client to tell you the full story, which assists in the negotiation strategies. And it gives you the advantage of showing your client, I'm here, I'm listening, and allows you to coach your client with patience through the mediation process. Now, do you have to explain to your client that any when you're inside the mediation, it's not a it's my way or the highway approach. Mediation advocates speak to their clients about the interests of their clients during the mediation process. They explain to them the reality of litigation. They advise them in terms of what are their legal rights, what are their responsibilities and potential outcomes. And in talking about, in involving themselves in all of that, they can talk to their clients about how to expand their knowledge in terms of gathering more information. This is what mediation does. It allows you the opportunity, the flexibility of gathering more information to make informed decisions. By having these honed communication skills, which are valuable in a legal practice, the lawyers can equip themselves with techniques to navigate client consultations to get the full story. Sometimes you would go, as lawyers, you would know, I go into a case and my client surprises me in court. I should have spent more time speaking to them. So, using the communication skills taught in mediation, you don't have to be a mediator to be a mediation advocate. You can use the skills taught in mediation, and inside those mediation skills are negotiation skills training, and use it to the benefit for the benefit of your client. So you will become more client centric. You will understand that you will have to adapt your practice to bring your client into the legal landscape, where globally, not just here, people are bringing in alternate dispute resolution processes. So now I see we've got 4 minutes, and I'm going to go on to the next one just to very quickly give you an understanding of the value of collaboration. We can bring in all our professions that I've mentioned, the lawyers, the therapists, the mediators, and give a fully fledged package to a client to ensure that they reach a resolution that is beneficial for them. What that means is a client will want to come back to you, not just in terms of when the next dispute arises. However, they will bring other clients to you. And I see this from my own practice. If parties walked away with a mediated outcome that was beneficial for both of them, they then send further work to our practice. The same will happen to you. If you are someone who shows that you're client centric, you will obviously influence clients to think, well, this person really cares about my issues. This person has heard me. This person has put me in the direction I needed to go. Now, the ethics behind all of this is to ensure that you behave in an ethical manner, that you do not address concerns in a way that derails the process. Every time you address the concerns of a party, you protect the integrity of the process. That is the ethics you must exhibit, your professional conduct of ethics, your rules as legal representatives that govern lawyers in mediation, and the ethics of a mediator. The ethics of a mediator is held to a very high standard because this process is unregulated. Now, when it comes to continued learning, not just the lawyers, and this is being here and listening to this webinar adds to your continued learning and understanding what is happening inside a mediation process, on how to influence your clients appropriately in understanding why they should go into mediation. The mediator themselves are also continuously learning best practices and contributing to the effectiveness in the collaboration between lawyers and themselves. So as a lawyer, you still owe your clients a measure of care. And if they know that this is a process and a quicker resolution that you put them down the path, they will appreciate that from you. Showing that you are client-centric and getting maximum value is the realization your client will reach in trusting you to come back as a repeated client. So your likability by putting the client first will increase. And that, of course, will benefit the reputation that you have and, of course, impact your profession greatly. So you don't want to lose a client because you are not prepared in terms of mediation. You will certainly obtain a client when they see how well prepared and strategized you are to enter into mediation. So I want to say thank you to you all. Thank you for coming to my talk with Mervyn and Vermeulen Attorneys. I am grateful to you, Mervyn and Nadia, for supporting this topic and for giving me a platform. So thank you, everybody, for your time and for listening. Again, foundational information, and we hope to take this a lot further in future webinars. Thank you, everybody.
And let me start over because I was muted. Viraj, thank you so much from my side and from the community side for an absolutely excellent webinar. I have one or two questions from the floor for you, if you'd be so kind as to just stick around for a minute or two just to go through them. Folks, I have put on the screen earlier and I'll pop it on again. Viraj is a prolific trainer. She does a lot of training in regards to mediation. Please go and have a look at some of her training. It really is worthwhile, whether you are a mediator, an attorney, or an advocate, or anything in between. In fact, it really is worthwhile to listen to Viraj when it comes to speaking about mediation. Folks, just before we go into the Q&A, quick reminder, Children's Act Deep Dive, if you would like to attend at the end of April, 23 and 24 April. And then next week, free of charge Family Law Roundup next week, Friday. To register for either of these or to join us on the WhatsApp chats, go to thinklegal.co.za. Right, without further ado, let's go into some questions. Viraj, there was an interesting one by Jennifer a little bit earlier, where she asked, could you opine on whether parties should ideally have their legal reps in mediation? Cost considerations, value of the dispute, complexity of the issues, etc., may be relevant, but there may be other factors. I think obviously this is quite a double-edged sword with some benefits, but quite a lot of potential drawbacks as well.
Thank you, Mervyn. Thank you, Jennifer, for that. Oddly enough, I did get that question in an email 2 days ago. Should the legal representatives be at the mediation? And that again is entire factors presented by Jennifer. Yes, I agree with that. It is the client's prerogative to decide if they want their legal representatives there, and that comes from exactly what we've been talking about today. The legal representative must explain to the client if there is a need for that legal representative to be there, by educating them on mediation and explaining to them that the mediator is actually going to be dealing directly with the client. Do you want me there? So in terms of negotiation strategy, where we have the complex issues, where we have commercial disputes, I do have lawyers in the room because they are mandated to be there. They have authority to negotiate. That is a commercial issue. Where in instances you have mediations where clients can actually speak up for themselves. If you have lawyers that they are bringing into the room, and if these lawyers are not well educated, they could derail the process. If the lawyer wants to advise the client, they will still have to advise the client outside of the mediation in a separate session. Mediators will also allow clients to take a break and make a call to their lawyers if they need to. So having them physically there is the cost impact on the client, and the client needs to be well informed. Do I want to incur this additional cost? If the lawyer is there as a support feature to the client, and it is conducive to, and the mediator can see it's conducive to the process, then by all means have the lawyer there. It is not mandatory though. And a mediator needs to be fully aware of when one party shows up with the lawyer and the other doesn't. Instantly, you could have a problem in the mediation where it's distrustful. The one party could be distrustful of the process. So what you need there is a pre-mediation meeting to identify why that lawyer needs to be there. The lawyer needs to explain to you, and then measure what would happen to the temperature of their mediation if one shows up with a lawyer and the other doesn't. So the pre-mediation meeting a mediator conducts with the lawyer, and lawyers, if you're in this pre-mediation meeting with the mediator, understand that the mediator wants to create a fair and balanced process without the other party who is new to the process feeling intimidated. So the mediator will ask questions and understanding what is the benefit of having the legal representative in the mediation, and does the other party understand this? And there's a lot of answers to this which we deal with in training. I'm just giving a very brief my opinion as Jennifer asked for it.
Phenomenal. Thank you so much, Viraj. Then one more question, a very interesting one. With regards to criminal activity, what do you do when it comes to light that there are financial crimes present, tax evading, fraud, etc.? Now, obviously, this is not necessarily, in my view, just as a primer for discussion on this, up to the mediator to go and report something like this. The parties have their legal representatives to advise them, and then obviously, if something like this comes to light, through documents which would otherwise be susceptible to discovery and are not privileged, I wouldn't surmise that falls under the blanket privilege or confidentiality of mediation. What are your thoughts on that, Viraj?
I agree with that, Mervyn, because in addition to that, how are they negotiating good faith? And what is the resultant outcome? Then they're wasting time in mediation and they know it. So
Mm.
you're coming to an outcome and then it goes to court and it falls apart. You then wasted time and costs in mediation, knowing that the outcome is done in bad faith.
Mm. And the implications, obviously, I would surmise for the mediation is that the mediation would essentially come to an end in most instances, unless by some big change of heart and or miracle or both.
I think it would be put on pause for the parties to then go back and the legal, this is again legal representatives, do reality testing with your clients. What do you think is going to happen when it comes to court and it is revealed that you conducted yourself in bad faith in mediation, and that is why the outcome report of mediation says the parties reached no agreement? What is the likelihood of the judge asking why? Why did that happen? Who caused this? So what are going to be the outcome in that judgment on a party who behaved badly? How is the judge going to view this? So
Mm.
the reason why mediation is put on pause is if the parties, like you say, do the light bulb goes on through the reality from their legal representative, and they're able to engage in good faith negotiations from the reality of what just happened, then they can come into mediation. But there's going to be a lot of wariness, and the trust has already been broken down. So there's going to be a lot of hard work from the mediator, from the parties, to build up trust. Again, it should start with negotiations there.
Mm. A final thought that comes from Tula, all the way from the Cape. She says it's vital to inform lawyers that their client will be heard. And then she refers to a situation that she was involved in where she had to correspond with a lawyer, and then mentions that the lawyer then became a part of the solution, resulting in a successful mediation. And I think it outlines the very important symbiosis between lawyers and mediators, which I think is very often overlooked. I made the point earlier as well. I don't intend to belabor it, but very often, as you pointed out, there are pain points, there are concerns on the part of lawyers. But then conversely, also, when matters go to mediation, very often the lawyers simply take their hands off the steering wheel and say, well, I am now supine. I'm out of the process while mediation is pending. And I think it's a lot of food for thought that you gave us today in terms of the fact that actually there is not just one, but several roles that attorneys and advocates can play in the mediation process.
True. When, and like Tula is mentioning, that when they become informed, like we're trying to do with them now, when you understand we are not the enemy, mediators are not the enemy, they're not pushing you aside and forgetting about you. We're actually helping you help your client. So
Mm.
they're still your client. And what happens here in a webinar like this is you now get to see how you fit into the dispute resolution process, not just mediation, the whole picture.
Mm. Fantastic. Viraj, from my side and from all our attendees' side, thank you very much for sharing your information with us today. Folks, for those of you who'd like to listen to this presentation again, it will be up on YouTube the minute I click end stream. Please do us a favor and share this far and wide to the lawyers in your life who you believe need to hear what Viraj has said. The message that, mediation is not the enemy and that there is an active role for lawyers to play in mediating successful outcomes for their clients. It is still an active role that we play in the process. We are not simply passengers. Eugene points out that he says all attorneys should listen to this presentation. I certainly agree with you. Thank you for that, Eugene. So from my side, from Nadia's side, and from Viraj's side, we thank all of you for taking the time to listen to us talk today, and specifically listening to Viraj chatting with all of you today. Once again, for more information on trainings presented by Viraj under the banner of Fair Practice, under the banner of AFSA, or under the other one for whom you do training, Viraj, please forgive me. I think the C air is
SA Legal
SA
Academy.
Legal Academy. Thank you, Viraj. I'm going to get hate mail from them later today. Please go to fairpractice.coza and see what else Viraj is doing. Otherwise, for those of you who are not yet on the WhatsApp, join us there. Keep the conversation going. Go to thinklegal.coza and join us in WhatsApp land for some robust and compelling conversation. On that note, I wish all of you a restful and a wonderful long weekend. So from myself, Viraj, and Nadia, thank you for watching. Thank you for listening. And we will see you again soon. I will be ending the stream in 3, 2, 1. Goodbye.